Of the Troy Zoning Board of Appeals to order. First, before we get into the business on the agenda, I'll do a brief introduction. The Board of Zoning Appeals is a group of 7 of your neighbors or peers appointed by City Council to pass judgment on requests for variances and other matters that are brought before them. A variance is a relaxation of the literal provisions of the zoning ordinance. Petitioners must indicate a hardship or practical difficulty running with the land that would warrant the granting of the variance. The board will hear the items in the order that they appear on the agenda. When an item is called, the chairman will verify that the petitioner is present. Then the city administration will summarize the facts of the case. The petitioner will then be given an opportunity to address the board to explain the justification for the action requested. After the petitioner makes a presentation and answers any questions that the board may have, the chairman will open the public hearing. Any person wishing to speak on the request should raise their hand, and when recognized by the chairman, come up to the podium and sign in on a sheet provided. The speaker should identify themselves with their name and address, indicate their relationship to the property in question, and state whether they are in favor of or against a variance request, and give reasons for their opinion. Comments must be directed through the chairman. Comments should be kept as brief as possible and closely pertain to the matter under consideration. Only one person will be recognized by the chairman to speak at one time. At the conclusion of public comments, the chairman will close the public hearing. Once the hearing is closed, no other public comment will be taken unless in response to a specific question by a member of the board. The board will then make a motion to approve, deny, or table the request. In order for the request to pass, a minimum of 4 votes are required for approval. If the request is not granted, the applicant does have the right of appeal the board's decision to the Oakland County Circuit Court. And with that, I would introduce the staff and members of the board here. First, on my far left is our recording secretary for this evening, Eileen Bittner. Then we have next to her, we have Glenn Clark, who's a member, Michael Bartnick, who is the vice chairman of the board, and then Thomas Stratt, who is not only a member of the board, but also our liaison to the Planning Commission. My name is Dave Lambert. I'm the chairman. Next to me is Alan Neal, another member of the board. And then the last member of the board who's here tonight is Ken Courtney. Followed by Ken is Paul Evans, who's a zoning and compliance specialist for the city, and Susan Lancaster, who's an assistant city attorney. And with that, we'll go into the formal meeting with the roll call. Ms. Bittner, can you call the roll, please?
Mr. Bartnick?
Here.
Mr. Clark?
Here.
Mr. Courtney?
Here.
Mr. Fisher? Mr. Neal?
Here.
Mr. Lambert?
Here.
Mr. Stratt?
Here.
Okay, thank you for the roll call. Next, approval of the minutes from the April 19th meeting. Is there a motion or questions on those minutes?
Mr. Chairman.
Yes, Mr. Clark.
I move approval of the April 19th, 2011 minutes as printed and presented to us.
Okay, there's a motion on the floor to approve them. I have one correction, so I'll include that as part of your motion. It's on page 8 of the minutes. I'll go down there. And it says at the very bottom of that, under public hearings closed, under the minutes, it says responding to Chair Lambert's question, the appellant said that building another church could afford some relief. I don't believe I asked the question, but I don't know who on the board may have asked the question, so I would suggest the minutes be corrected to just say a board in response to a board member's question. Any other corrections to the minutes? Seeing none, is there a second to the motion to approve? Mr. Courtney seconds it. The minutes be approved with that one correction. Could we have a roll call, please?
Mr. Clark?
Yes.
Mr. Courtney?
Yes.
Mr. Fisher? Mr. Neal?
Yes.
Mr. Lambert?
Yes.
Mr. Stratt?
Yes.
Mr. Bartnick?
Yes.
The motion passes and the minutes are approved with one correction. Now, I believe, I'll turn it over to Mr. Evans, we may have at least one postponed item that has been requested for postponement again.
Yes, that is correct. Case B, which is 4820 Livernois, the applicant has requested that the board postpone this matter. The correspondence did not indicate to what date they wanted it postponed to. I suggest perhaps we just postpone it to our next meeting, which is June 21st, 2011. That's our next regular meeting.
member of the board wanted to offer a motion to postpone. Mr. Courtney, is there a second?
Second.
Mr. Clark seconds it. Any discussion on the motion to postpone? Seeing none, we'll take a roll call on the motion, please.
Mr. Courtney?
Yes.
Mr. Neal?
Yes.
Mr. Lambert?
Yes.
Mr. Stratt?
Yes.
Mr. Bartnick?
Yes.
Mr. Clark?
Yes.
Motion passes, and I believe that was for our June meeting, that will be there.
Right, June 21st.
June 21st. Okay, the only item we have as far as, yes, Mr. Stratt.
Is there anybody in the audience that came for that particular item?
Was there anybody here that was here for that item B, the variance request for Minal Gada and Ashish Manik? I didn't think so, okay. Thank you for checking, though. Okay, the only other item we have as far as variance requests is a variance request from Monsignor Zahar Toma Kajbu from the St. Joseph Chaldean Catholic Church. And I don't believe anyone is here on behalf of the church. Mr. Evans, do you have any updates on this situation?
No, I spoke to him last week. He's aware that they're on the agenda. He did indicate to me that he did not have any additional materials at the time we spoke on Wednesday to provide the board. That's all I know.
Is there anyone that would like to address the board on this issue? Yes, Mr. Sanzika?
Mr. Chair,
Yes.
I think the board should decide, first of all, if they're going to go forward and hear
Okay.
the item before you let anybody from the departments or from the audience speak. This is one of those items where you can still vote on it, even if they don't appear. It's up to you, or you can make a recommendation to postpone it. If you are going to hear the item and vote on it tonight, then you can ask people from the audience to vote, to appear. But if it's going to get postponed, you should ask anybody here to come back. It depends on what the board wants to do.
What would the board like to do? Mr. Courtney?
Since I thought they were going to do some traffic study, I would like to see that. And that possibly could make a big difference in my vote. So I would like to postpone the item. Give them another month to comply.
Okay. Mr. Neal?
Mr. Chairman, I have nothing wrong with what's just been said, but since we do have residents who are here, I don't have anything wrong with letting their comments be part of the record and allow for postponement, but people have came, so.
Ms. Lancaster, is that appropriate for us to?
Well, the problem is that the petitioner is not here to respond, and it gives the appearance that there's been a denial of due process because if you allow people from the audience to speak and they're not here to respond to those comments, they would either have to listen to the minutes next time or be informed. So it's a little bit awkward because we have that issue that there's nobody here with the agenda item.
Would they be able to, if we postpone, and I have no idea if the board wants to do that, but if we were to postpone action, would they be able to still address the board under the public comment section?
Do you have, is there a public comment?
Yes.
section?
You're referring to item 5 of
Item
tonight's agenda,
5.
Dave? Yeah.
Anybody can address the board about anything at that particular item. It's still, what we would do is, I would suggest the chair ask that person to come back and repeat those comments because there's no way to convey them to the petitioner. If they still want to comment, that's fine, but we need the petitioner here so they get a chance to respond.
Mr. Chairman?
Yes, Mr. Clark.
Thank you, Mr. Chairman. Thank you to our legal counsel because I was going to ask the same question that Mr. Lambert, our chairman, just inquired of you, and I thought that was the cleaner way. I think that, and of course, I just would like to inquire of legal counsel. I think it would be more clean if we move to postpone this. I would be in favor of a motion to postpone until the June meeting to give the congregation greater opportunity to address us with more information or maybe none, no more information. But on that note, I think if I could inquire of legal counsel, if a person from the public addresses us under public comment, in particular on that, or on this related issue, then I think the appropriate action for the board would be to have no comment in response, correct? In that the petitioner is not here to
Right,
address us.
public comment usually does not require that the board discuss the item. It's just things that the public wish to bring to your attention about the agenda items.
Mr. Chairman?
Or anything else, I
Let
guess.
me recognize Mr. Courtney first, and I'll get to Mr. Stratt. Mr. Courtney?
I have no problem pushing people off the month, but if somebody can't be here next month, I would definitely like to hear their comments, as well as suggest that they put it in writing and ship it to us.
Okay.
Yes, not
Beyond that, I don't want to hear the comments that I can hear next month.
And on that note, we do have the capability to accept email comments, letters, and the board is familiar that we can get those to you in advance of the meeting.
Okay. All right. Mr. Stratt?
Mr. Chairman, thank you. This is the second postponement. This is the third time that people have come out to actually communicate with him. And this is going to be the fourth time, and I know that a lot of people were there at the Planning Commission meeting, that were not here at this meeting, that complained, and there's a lot of mixed emotions here, I think, in terms of communicating to all the people that are really being affected. I am not in favor of postponing, because I think they've had ample time, and we saw the documents that they did present, which did not include any kind of a traffic study. So I can only assume that they're not prepared to submit a traffic study. At least I don't know, Paul, maybe you've received it. But I have not received anything along those lines. So my position is, I think that postponing again for the fourth time would be four different hearings that they would have had.
Mr. Chairman?
Mr. Neal?
The question for staff. When you spoke to the applicant last week, they gave you did they confirm that they would be here?
No,
No.
they didn't say either way, as a matter of fact.
Okay. From your recollection, do you recall asking specifically if they would be?
No,
Okay.
I didn't ask.
I'm not saying that you should have.
And they didn't
I'm just
say.
curious. Okay. But they were informed that they were definitely on the agenda.
Oh, I don't believe there's any question
Understood.
that they're aware. I did speak to the Monsignor, and I don't think there's any question that he's on the agenda. You know, if I recall correctly from the meeting, the original motion was to postpone the matter for, I believe, 2 months, and then it was staff's suggestion that if they could perhaps provide and get their additional information together for the board in a shorter period of time, the applicant could save some time. So I think it looked like what the board decided to do was say, okay, well, if you can move faster than that, you'll be heard faster. So I believe they're aware.
Okay. Mr. Chairman, may I just make a comment?
Sure.
I was kind of on the fence regarding this. My initial thoughts were more in the line of Mr. Stratt's, and in consideration of everything I've heard, I would have to say that that I'm in favor of Mr. Stratt's opinion on this, too. That's all.
Mr. Courtney?
Yes, since last month was the first time that I think they really understood a traffic study was necessary, and we were going for a 2-month postponement and then cut it back. The board cut it back, saying if you're done, you could have it then, and if not, it would be the second month. I think we kind of told them we would go within 2 months. And I don't think it's unreasonable, since last month really appears to be the first time they understood that they needed traffic work.
Chairman.
If they understood beyond that, I didn't understand that they knew.
Mr. Clark?
I think all the comments are good comments. I'm just trying to put myself into the Monsignor shoes for a second. Maybe there was some confusion, I'm not sure. Clearly, we saw some very active people in our community that were represented the congregation and the condo owners last time. And on that note, and after Mr. Evans mentioned it, I did recall the 2-month ordeal or the original conversation. I just think, yes, it's not, I think Mr. Stratt's concern about the Planning Commission and the Board of Zoning Appeals probably is applicable to Mr. Stratt more than anything else because he's a member of both committees, and I'm not trying to undermine his comments. I just think that I'm in favor of postponing one more meeting. I'm kind of surprised that if they were not prepared to submit something, that they wouldn't have contacted Mr. Evans and our city staff, and I'm just wondering if it's just a complete oversight on their part, and wouldn't we feel horrible if they did have a traffic study in the works? Having said that, I spoke to Mr. Evans at length about this on the telephone just, I believe, last week, and I spoke to at least one other member of the board, I think after the last meeting, and it seems that there's a belief that if there is a proper traffic engineer employed in this process, there could perhaps be a resolution to their issue, and I think that we all kind of at least are aware that there might be a possible solution, maybe not a probable solution. So having said that, I would move to postpone this to the June meeting simply because I want to avoid every possible issue with the congregation in that we may have miscommunicated to them, they may have misinterpreted the communication from us, and maybe it was on both parts. I'm not exactly sure, but clearly they're good people.
Can we open the meeting to the public before the meeting?
Is that a motion?
That was a motion.
Okay.
Thank you.
Before I hear a second, Mr. Stratt, what was your
Yeah,
question?
I'd like to hear from the public if anyone has anything to say on this before we vote on it.
Ms. Lancaster, is that an appropriate request?
If it's a motion to postpone, it would not be. He can talk during the public comment part, because again, we have that due process issue where the petitioner is not here, and it is just a motion to postpone. He could be heard in the public comment section, and there would be, because otherwise if you start talking and debating it, the petitioner is not here, and we have that due process issue.
Mr. Chair.
Is there, first, before I recognize you, is there a second to Mr. Clark's motion?
Second.
Okay. The motion's been made and seconded to postpone action on this until our June meeting. Is that?
Yes, and can you ask if anybody cannot be here next month that has comments? Because that makes...
Yeah. What I'll do that is, if this passes, what I will do is, during public comment section, you'll be invited to come forward to address this issue.
Okay.
And so you can address this tonight, or you can wait until next month if this passes. Mr. Neal, I know you had a question. Normally, during a motion to postpone, it's not debatable, but a point of privilege.
Thank you. My question, Mr. Chairman, is if I could ask a question of Mr. Stratt, who's the designated representative of the Planning Commission. What I recall during the last meeting is that one of the results of the Planning Commission, and I'm paraphrasing and remembering your own discussion, was that at that time it was strongly suggested to them, and I don't know the date of the planning meeting, is that they needed a traffic engineer consult.
That is correct.
So that was conveyed to them as part of the...
Very clearly.
Okay.
Almost unanimously, and there is a member of the Planning Commission that's present that I think could verify that comment, but I think it was almost unanimous that we all agreed that there was another possible solution, or there was a better solution, that they should contact a traffic engineer before they did anything else, any further. They still have to come before the Planning Commission. It's a special use approval. So there is conditions on a special use approval on that basis as well. So regardless of what the ZBA does as far as the variance, still has to go before the Planning Commission.
Okay.
My understanding, anyway.
I just recall from the meeting last month, at one point I had asked the question.
No, it was very clear.
No, I just remember at one point I had asked one of the petitioners if you had considered a traffic engineer, and then a few minutes after that, I believe is when the discussion that you had relative to the Planning Commission meeting. I just wanted to see if my recollection was correct. Thank you.
With that, the motion to postpone will go for the roll call to postpone until the June meeting.
Mr. Neal?
No.
Mr. Lambert?
Yes.
Mr. Stratt?
No.
Mr. Bartnick?
No.
Mr. Clark?
Yes.
Mr. Courtney?
Yes?
I believe the motion fails for lack of a majority.
Right.
Any other resolution? Mr. Bartnick.
There is pending then from last month a motion to deny the request because the proposed driveway along the western edge would cause an adverse effect on the properties in the immediate vicinity based on the testimony and exhibits.
So that motion is in front of the board then. And at this point, if that's an active motion, I could open this up for a public hearing. Is that correct, Ms. Lancaster?
At this point, you have no decision because you didn't vote to postpone, so if you want to open it up to the public and for another motion, unless someone wants to, that voted with well, there's no majority, so you can't re-vote on that issue. So yes, at this point, you can open it up and make your decision whether or not you're going to pass it or not.
At our last meeting, we had a public hearing which was open and closed. If there's no objection from the board, I will reopen the public hearing this time, so come on back up.
Well, thank you, Mr. Chairman. It's an honor to be in front of the BZA. My name is Phil Sanzica. I'm on the Planning Commission, member with Mr. Stratt. Very happy to be able to come here tonight. I just have to echo exactly what Mr. Stratt had said. At the Planning Commission, we did suggest to the petitioner that they do submit to a traffic study. In fact, I recall talking to the Monsignor specifically out in the parking lot after the meeting, suggesting even a consultant who would do that. I am an engineer. I'm not a traffic engineer, but it's pretty obvious to me that there's a better way to design the site so that no variance would be required. And with proper, possibly the acceleration lane to allow 2 lanes of traffic through the middle of the site, striping of the parking lot, possibly during the high, during the major times when they have the biggest audiences, have people in the parking lot to direct traffic. I believe that there's no reason in the world why they have to have a driveway along the west property line in order to eliminate all the setbacks and the hardship on the residents. I did sit, and we did have a hearing, and I believe that this will definitely impact the residents in the subdivision, in the condominiums to the west. So I strongly agree with the several members of the zoning board, and I do encourage them to deny any request for rezoning.
Questions from board members? Mr. Stratt?
Yeah. Do you recall how many people there were in the audience that were opposed to this at our meeting, at the Planning Commission meeting?
Oh, yeah, there were over a dozen people here, as I recall.
There were quite a few.
Yes.
And as you can see, there's hardly anybody here now.
Any more questions? Mr. Evans?
I would have to say we did not have a public hearing. The Planning Commission was not authorized to act on that because variances, so they did not hold the public hearing. They merely accepted the plan. As a matter of fact, the meeting minutes that were one of our agendas of that meeting did not indicate any comments or sentiment from the public, and that would not be the appropriate time for the Commission to hear it until the public hearing. So I just wanted to clarify that for everyone here tonight.
That's correct.
Mr. Bartnick?
Thank you, Mr. Chairman. I just wanted to clarify that you're here just as a private citizen.
As a citizen, yes.
Of the city of Troy. Thank you.
Absolutely.
Any more questions for Mr. Sanzica? Seeing none, thank you very much.
Thank you, Mr. Chairman. I appreciate this opportunity.
Anyone else that would like to address the board on this issue? Yes, sir.
My name's Ed Pichet. I'm the secretary of the Morelis Homeowners Association. We're just to the east of St. Joseph Chaldean Church. And the proposal that the church has brought forward is asking for Wexford condominiums to trade off what is currently maybe 6 weekends a year of inconvenience for inconvenience literally every weekend. And I think before making that final decision, or whatever the decision is, that it really needs to be the right decision, because whatever goes in is going to be permanent. It's not going to be coming back out. In the auto industry, there's a 5-phase process that's used for problem solving, and I've worked in the auto industry for 37 years, and I'd like to go through that, because it's a pretty rigorous thought process, and I think it would apply here and to other situations also. The first question is, what exactly is the problem that's trying to be solved here? Is it the traffic backup? Is it police directing traffic? Is it the cost to the church of that traffic direction? And I know a lot of the police officers have been laid off because of the current budget cuts. So that reduces the availability of the officers to direct traffic. So the first question really is, what exactly is the problem that needs to be solved? Second question is, what's the root cause of that problem? If you could change one thing to make the problem come and go, what exactly would you change? Once you understand the problem and what's causing it, you can put in either a quick fix or the final fix, whatever it may be. And the real question is, what exactly are we trying to accomplish? If the problem is the traffic backup, what's our measurement to know that the problem has been solved? Is the measurement that the police no longer have to go out to direct traffic, Christmas, Easter, and other special events? And if we fall short of that, has the problem been solved? So I think the real question needs to be, will this be the final fix where the police no longer need to direct traffic? And that should be the ultimate goal. So that, and if that is not the case, what's the backup plan? Is there another plan that could be put in place to address the issue? If you don't understand the problem and you put in the wrong fix, you're going to spend a lot of time and money and still have the problem. So I'm asking that as the Zoning Board of Appeals and the church work together, that you come up with the right fix. That's it.
Thank you. Any questions for Mr. Clark?
I have a question for our legal counsel. Mr. Chairman, you called for the public hearing before I could, or for the public comment before I could inquire of our legal counsel, Mrs. Lancaster. I'm looking for clarification on your comment regarding the advice you gave to the board about the majority, someone who voted with the majority, which is a little confusing because we had an equal or a tie, but of course, in a tie, the motion fails. I'm sorry, what was the option you gave to the board, once again?
When you have a motion that doesn't pass, you can, if there's a majority, which we didn't have tonight, a member of the majority can vote, can make a new motion in an attempt to resolve the fact that you didn't have a vote. That wasn't the situation under Robert's rules tonight because you had a tie vote, which is the same as the vote didn't pass. So that might come up in the future, but it wasn't applicable to tonight's rulings.
Thank you.
Yes, Mr. Evans.
My apologies to everybody here, including our planning commissioners. At the meeting of the Planning Commission on January 11th, there was a public hearing, and your comments about what people were saying, well, anyways, there was a public hearing, people commented, so my recollection, as I indicated earlier, was wrong, and I just wanted to clarify that for everyone here, and my apologies to everybody.
Anyone else that would like to address a public hearing?
Mr. Chairman, I have a question.
All right, well, let me close the public hearing then if no one else wants to address. Does that close the public hearing? Okay, Mr. Neal.
So do I understand it then, between the Planning Commission and the last month's ZBA meeting, we've had 2 public hearings that have been advertised?
Yes.
Okay, thank you.
Mr. Clark.
Thank you, Mr. Chairman. Can I just inquire of staff what the, it's a big if the church has contracted with a traffic engineer, what are the filing fees to bring that before the board again regarding a variance request if they chose to go that route?
Well,
Meaning they would, I'm just looking for clarification, if this is not postponed tonight, then therefore they will lose what? How many dollars?
$150.
Okay.
Any, Mr. Courtney?
Yeah, so you don't get the wrong idea. I don't expect them to come, after they have a traffic engineer, to come back with the same request, so I see nothing wrong with denying the current request anyway. I expected the item to be a little bit different, because I thought the traffic should come and go midway and further east, not going to the west. So I guess it may sound like I'm changing my spots, but I was thinking of tabling it to save them from doing $150. And if they didn't come through with the change, I was going to vote to deny anyway.
Any further comments or a motion from board members? No. Let me clarify. Do we have an active motion on the floor in front of us or not? We do. The motion to deny is in front of us, I believe. Is that correct, staff?
Yes.
Just to make sure, who was the maker of that motion?
Mr. Bartnick?
Okay.
And seconded by Mr. Neal, I believe.
Yes.
It was a motion to deny the request, but the motion was superseded by a postponement resolution.
Right.
So we have that motion on the floor to deny the request. Any further discussion on that motion then? Seeing none, we're ready for the roll call.
Mr. Neal?
Just for clarification, a no vote denies the motion?
No, a yes vote denies the request.
A yes vote denies the request?
Yes.
Yes.
Mr. Lambert?
Yes?
Mr. Stratt?
Yes.
Mr. Bartnick?
Yes.
Mr. Clark?
Yes.
Mr. Courtney?
Yes.
The motion passes. The request for the variances has been denied. Okay, with that then, we are done with variance requests, and we'll look at the next item on the agenda, which is any communications. Any communications from staff that you want to share with us?
You've all been provided a copy of my email regarding minutes, and if there are no comments or questions regarding that, we'll let the communication stand.
Okay, thank you.
I did have, Mr. Chairman.
Yes, Mr. Bartnick.
Thank you. I did have a couple questions regarding that, and maybe it segues, maybe we should have a continuation of the public, of the study session at this time. But according to the memo, then, what we're trying to accomplish is, as I see it, are we going to have a more complete record, or we're going to have the same record we've had all along, just in a different format, which is saving the video tape of the meetings and then just having an action type of minute?
Right. I think the intent of having the video with the audio is to have what some would think is the most accurate record of exactly what transpired at the meeting. Of course, any record contains the case file, the application, and whatever goes with it. But essentially, since we tape the meeting already, we can archive those electronically and save substantial time with staff preparing the meeting minutes. That also might save individual board members time when it comes to prepare for the next meeting when you review those minutes. As to whether it's a more accurate record, I would opine that it's probably a more accurate record than the written meeting minutes, although I want to suggest that our written meeting minutes are in any way inaccurate. If anything, they're very accurate.
Right, I wasn't suggesting that. It's just that, as I read the memo, right now, the video tape or the electronic recording, video recording, is only kept until the next meeting? Is that?
Right. The current process is not to keep it for any described time. Now, we've worked, staff has worked with the IT department and also the video department to archive those. And those are readily accessible to staff. If we get someone who wants to watch it from the public, they can come in and watch it, even if it's still not available on the cable.
How are they backed up? How are those, how are they archived? Is there duplicate record somewhere?
I don't know, and I can find out specifically how it works. I know it's an electronic format as opposed to, say, exclusively placed on some sort of disc. Compact disc or DVD, for example. I do know that our IT department takes great measures to back up and create duplicates of everything in all our computer drives, emails, files, that kind of thing. But I can find out specifically and report back to everybody as to what measures are taken.
Do we have to do anything with regard to this memo, or is it just that we're going to be seeing minutes presented to us in this manner?
Correct.
And if we wanted to make any additions or subtractions, we would just handle it like we have in the past?
That's correct. This is an informational memo, and certainly 7 more sets of eyes that we want to do, I think, is beneficial, is also as well to keep everybody in the loop.
Thank you.
Mr. Chairman.
Yes, Mr. Clark.
Mr. Evans, or maybe I can inquire of Mr. Stratt, if I'm reading this right, this is a draft minutes for the Planning Commission, so I assume that the Planning Commission is not operating under the same system currently? Is this that you just created one draft under item 1? I guess the real question is the Planning Commission using this system that you are communicating with us right now, or is this something that...
Yes, we've asked that IT create repositories for both groups of meeting minutes, and it's the planning department's intent to do this for both boards.
So the question is, how long has the Planning Commission been using this system? Just recently, or?
Yeah, this is just recently. This is just in the last month or two. I'm not sure. I'm not sure if they've used it yet.
Not yet. Not that I'm aware of.
You know, now that I remember, Cindy Stewart, our communications director, this meeting and everything that's transpiring tonight is the test to see how well we think it'll work. The dry run, so to say.
You're the guinea pig.
That's right.
Sure.
Mr. Chairman?
Yes, Mr. Neal.
Mr. Evans, just your thoughts on how much of a time saver this is for staff to do it this way?
Probably anywhere between 3 to 5 hours per meeting.
Really?
Yeah.
Okay, thank you.
Is this an appropriate time for us to go back into the study session then and cover that, any things that we didn't cover, or Mr. Courtney?
I would prefer we finish our agenda
okay, we
first.
can do
Finish the
that then.
agenda, and then we'll...
All right, then we'll do that.
And since there appears to be no public, I would like to go to item 6. And I move...
Let me make sure in case Mr. Sanzika wants, so there's no one here for the public comment? Okay, now you can go
Mr.
on.
Chairman, I have one comment.
Yes.
I just wanted to thank city staff for putting on the training session today. Unfortunately, as we all looked at our calendars last month, my calendar was completely free for the hour training that Mr. Evans prepared for us. Unfortunately, I belong to a committee that was created by the Michigan legislature via statute, and under the bylaws of that organization, the chairman of that entity can call a meeting for not more than 10 days in advance notice, which that meeting fell tonight. So unfortunately, I was required to be there, and thus I missed Mr. Evans' presentation to us. And I'm looking forward to receiving his email with a JPEG or however he's going to present it to me, so I can make sure that I don't miss anything. And I know it was televised, so therefore I'll be able to watch the video. But I do want to, and I did call Mr. Evans to let him know as soon as I found out. But at the end of the day here, I just wanted to make sure that, staff understood. I certainly appreciated the time that they spent, and I'm looking forward to reviewing it. So please excuse my absence earlier.
We're glad to have the video for you now.
Excellent.
The good news is they have more to give us after we're done with the miscellaneous business items, so. Okay, Mr. Courtney.
Yes, I'm going to make a recommendation or make a motion that Mr. Lambert be chairman and Mr. Bartnick be vice chairman for next year. I've been entirely happy with both of them sitting in the chair seat, and I'd like to see us continue with the same two.
Point of, I appreciate the comments, but I think the more appropriate method is to actually have the nominations for each of the two seats followed, the nomination of the first seat followed by the election of the first seat, and if there is a victor on that seat, then to proceed to the second seat with nominations followed by an election of that seat.
Well,
I think that's what's required
We'll
under...
follow that, and with the recommendation, Mr. Courtney,
I would like to first comment that we can do it any way we want. In the past, with the exception of 2 elections, it's always been both at the same time. I would yield to whatever the group wants to do, though.
Mr. Chairman.
Mr. Clark.
I would second Mr. Courtney's motion, and I believe if we inquire of Mrs. Lancaster, I serve on another public body, and we have an annual board of officers elections on the board, and we take it all as one motion. And I think that's Mr. Courtney's motion, my motion as well now, unless I think Mrs. Lancaster can direct me differently, but unless there's a motion to bifurcate, is that correct?
That's correct. You can vote both members in at the same time unless there's a subsequent or a substitute motion to bifurcate right now. So if there's a motion and you're seconding, you can vote on the slate, or if somebody wants to motion to bifurcate, you can do it that way.
I'll make a motion to bifurcate.
Okay, first let me recognize the first motion. So the motion's been made to re-elect the officers by Mr. Courtney, seconded by Mr. Clark. That's on the floor. Mr. Bartnick has moved to bifurcate the election. Is there a second to that?
I'll second.
Mr. Stratt is second to the motion to bifurcate.
I have a question, if I may, to Susan. Susan, Ms. Lancaster, I'm sorry.
That's okay. That's my
It
name.
seems maybe 5 or 6 years ago, the Planning Commission was mandated to make sure that we follow specific procedures in the elections. Do you recall that?
I recall that at one time we had a council person or a planning commissioner that wanted a specific strict parliamentary procedure involved, which was very involved and very confusing. The rules, Robert's Rules of Orders, allow you to adopt how you want to do this. And if you can adopt, and I've seen many a board adopt what I call a slate. However, that's what bifurcation's about. You don't always have to do the slate, and if you want to bifurcate, that's perfectly acceptable.
That was superseding the Roberts Rules, if I recall correctly.
It was what?
It was actually overdrafting what the Roberts Rules were.
That would be a good assessment of it, I think.
Yeah,
I
because
remember it was very
mandated that
confusing.
we must go through the process. But if it didn't apply here, then it doesn't make any difference. So I just was wondering if it applied here.
I do remember that election. That was a pretty confusing one.
Yeah.
Okay.
All right, there's been a motion made and seconded to bifurcate the election. Any discussion on that motion?
So, Mr. Chairman, point of information, just for clarification, I believe a yes vote on the motion to bifurcate would be a vote to separate the elections, and a no vote would be to keep them together as one ballot.
Correct.
Is that correct? Okay, thank you.
Any discussion or questions on that motion to bifurcate? The roll call, Ms. Bittner?
Mr. Stratt?
Yes.
Mr. Bartnick?
Yes.
Mr. Clark?
No.
Mr. Courtney?
No.
Mr. Neal?
Yes.
Mr. Lambert?
Yes. So the motion's been made to bifurcate,
Yeah.
and then we are now then into a situation where the appropriate thing is to have nominations for the position of chairman, or the motion then to just...
You just split my
Okay,
motion
all
into
right.
two pieces.
Okay, so then the motion in front of us is to re-elect me for chairman, is that the motion? Okay. And it's been seconded, so any further
Unless
discussion?
somebody wants to.
Unless somebody wants to change it. Mr.
Well,
Barnett?
I would nominate, or suggest that we nominate, or open it up for nominations for the chair. And along those lines, I would nominate myself for the chair.
Mr. Chairman?
Yes.
We have a motion on the table. If you want to propose a substitute motion, otherwise we vote on the motion that's on the table.
I think it's, if I may respond, I'd like to have some parliamentary response to that, because I think it's inappropriate to have an election for a chairmanship where there is only one nominee, and by virtue of a parliamentary motion that is on the table, I think the purpose of the election here of chairs and of the vice chair is to have nominations from the membership of the board, have the opportunity for those memberships, for those nominations, and then to have the election. So I don't know that that's a proper motion, or the proper interpretation of what you've just
That is the motion
proposed.
that was just divided.
Okay, let's back up a bit, and if I may, Mr. Chair?
Yes.
We had a vote to bifurcate, so the proper procedure would be to put some names in nomination, and then suggest a motion, and then somebody make a motion. So, and I think it's out of courtesy, you want to ask the person if they're willing to serve. I believe that that might be acceptable.
Okay.
Excuse me, Mr. Chairman.
Mr. Courtney.
I've had enough parliamentary procedure to know that that is not exactly what we do. We have to make some decision on the resolution that's out there. It can be done by a motion to make the change, but it can't just be done because we want it to be.
Are you
Somebody
saying
had-
there's a motion on the floor?
There's a motion that was divided into two parts. A motion to elect a chairman by name and a vice chairman by name, which was divided into two parts. So you still have a motion to not to nominate, to elect one person for chairman. You have a separate motion to elect one person for vice chairman. If we want to make a change, we have to have a resolution to make a change to the action that's being taken.
Okay, I
You
guess
have
I'm
two
not
motions
following.
up there.
A motion for chair? Are you saying they should be done together?
We have a motion for chair by name. Doesn't say we can add names.
Well, the motion to bifurcate,
Splits into two parts.
correct, for chair and for vice chair.
Right.
Okay.
Now, we've split them into two parts, but each part has a name. It's a motion.
So are you saying the only person you can vote for is the person that was,
Unless you make another motion, yes.
okay, well, there is a motion. In other words, you want to vote on the motion to whether or not Mr. Lambert will be chair.
Correct.
All right?
Unless somebody wishes to put in a substitute motion.
But we don't have that motion on the floor. Are you making a motion that Mr. Lambert will be chair?
No, that is already on the floor.
Okay, you're just saying you're bifurcating the prior motion.
That's what was bifurcated.
Okay. I read that to be that you're bifurcating the election of chair and vice chair. You're reading it to be that you're bifurcating the election of Mr. Lambert and Mr.
Bifurcating the resolution, which was a resolution to elect one person for chair, elect one person for vice chair. Bifurcation is separating it into two motions. Doesn't open it up for anything other than voting, unless
There's a substitute motion. All right. I guess the question is there a substitute motion? And I assume that that was what was being presented, was a substitute motion to nominate.
He could present another
Okay,
motion.
so the motion would be to nominate instead of naming
Yeah,
Mr. Bardnick.
Right.
He would make a motion to open to nominations. I think we've got that straightened around.
So, is that what you want to do, Mr. Byrne?
Well, if I may, I think it's inappropriate. I guess I would look for some citation. I'm looking at section 46 of Robert's Rules of Order, newly revised 10th edition, page 423, lines 1 through 5 or so, and it is headlined, "Impropriety of making the nominating ballot the electing ballot." Sometimes a motion is made to declare the nominating ballot the electing ballot. Such action negates all the advantages of a nominating ballot and is, in effect, the same as having an electing ballot without any nominations. So I would suggest that the interpretation that you've supplied is along these lines, or maybe precisely what is suggested here, and I think that that's improper. I think the more proper thing is what was suggested by the attorney, which is the bifurcation of the motion was to bifurcate the election of the chair first, and then secondly, to have the election of the vice chair. The procedure then is to open, for the chair to open up the first seat for nominations, take those nominations, close those nominations, inquire of the candidates if they want to take them to be voted upon, and then have the election of that first chair. Unless there's something else that you can point to. I respect what you're saying about your experience, parliamentary experience. I'm just looking at the book here, and that's what I see.
what you have to do, as far as I'm concerned, what you have to do is present a motion to replace what I have made. In other words, that you would go into the election and accept nominations for the elections of.
I don't see how that's proper. I mean, I don't know
Mr.
that your
Chair.
interpretation of the motion is proper. I don't think it's
Well, we've
accurate.
already bifurcated the motion. So we've obviously accepted it. It's been accepted by this body, otherwise it wouldn't be on the table.
Mr. Chairman?
So now you have to do something with
Let
it.
me call on Ms. Lancaster, then I'll get you.
Mr. Chair, rather than fight about this all night, because everybody's interpretation is differently, and I don't have the same book that you have, my little notes say that for elections, the chair must call for nominations. So I would suggest that the chair say nominations are now in order for the office of chairman, and a second is not required. Any number of persons may be nominated, and then once your nominations are in, someone can make a motion to vote. At least that's my little
Yeah,
summary.
Except we have a motion on the table, it's been accepted, and it's there.
Mr. Chair, for purposes of moving on tonight, I suggest we just open it for nominations and take it from there.
Okay.
All right?
Well, let me hear from, I've heard from Mr. Courtney. Mr. Bartnick, did you have another thing you wanted to say or not?
I think she answered the
Okay,
question.
all right. Because I'm not obviously a disinterested party, and the great ceremonial duties and pay that goes with this position puts me in a difficult position, I'm going to make the ruling and follow Ms. Lancaster's recommendation that we accept nominations from the floor, otherwise we'll be here debating parliamentary procedure for hours on end. So, Mr. Courtney, do you have a motion?
Previous motions should not exist in the
Correct.
minutes.
So if you'd like to nominate someone for chair, Mr. Courtney?
Chairman Lambert.
Okay. Is there another nomination for the office of chairman? Somebody want to, you want to nominate yourself, Mr. Barton?
Thank you, Mr. Chair. I wanted to nominate myself for the
Okay,
chairmanship.
all right. Any further nominations for chairman?
Mr. Chairman?
Yes,
I'd
Mr.
move to
Clark.
close nominations
Okay.
for chairman.
All right, the motion's been made to close the nominations for chairman. Could we have a roll call on the motion to close nominations?
Mr. Clark?
Yes.
Mr. Courtney?
Yes?
Mr. Neal?
Yes.
Mr. Lambert?
Yes.
Mr. Stratt?
Yes.
Mr. Bartnick?
To close nominations?
Yes.
Yes.
Motion's been made to close nominations. Now I would assume the roll call would be for a person to either vote for Mr. Bartnick or Mr. Lambert, so.
Mr. Chairman,
Yes, Mr. Stratt.
is there any way that this could be done so that it is in secret ballot rather than by,
I don't
no,
think so.
it has to be?
Yeah.
I
Okay.
think secret ballot is,
Probably a violation of the Open
Violation of
Meetings
the law.
Act.
Exact, that
Was
is
it?
correct.
Okay.
Okay, so would you call the roll?
This will be for Chair Lambert.
Yes.
Chairman.
Mr. Clark?
Mr. Lambert?
Mr. Courtney?
Mr. Lambert?
Mr. Neal?
Mr. Bartnick?
Mr. Lambert?
Lambert.
Mr. Stratt?
Art.
Mr. Bartnick?
Bartnick.
The vote is 3-3.
Well, this is one reason why we're going to start having alternates on this board, if you haven't already guessed. So we have no motion on the floor, and you're going to either have to reopen nominations, I would suggest, or
Postpone.
we have to leave here tonight with the chairman. So whatever Robert's Rules of Orders provide, I would suggest that someone propose a new motion for chair, or for, ask for a recount or some such thing, because we have to move on. I mean, I suppose we could conceivably postpone it till we have a full board, if you think that would help.
Mr. Chairman?
Yes, Mr. Clark.
It's rather unusual,
I
but
would move, I would like to nominate Mr. Lambert for chairman.
Are there any other nominations for chairman?
Mr. Chairman?
Yes.
I would like to nominate myself. I would suggest that it's necessary that a chair be in place prior to the beginning of the rest of the next of the meeting, and that more appropriate action would be to postpone the election until the beginning of the next meeting. First item on the agenda.
Point of order, Mr. Chairman, that's two different issues, and one is not related to the other regarding the active motion. Well, I made a motion, a nomination, and I heard another nomination, so I believe somebody could call for closing of nominations, and we could proceed to a vote. And after that ballot's cast, and we can consider where we're at.
All right. Is there a motion to close the nominations for the office of chairman?
So moved.
Okay, second by Mr. Stratt. Any discussion on the motion to close the nominations? Roll call, please, on the motion to close the nominations.
This ever happened to Chris?
Mr. Courtney?
This is to close nominations?
Yes.
Yes.
Mr. Neal?
Yes.
Mr. Lambert?
Yes?
Mr. Stratt?
Yes.
Mr. Bartnick?
Yes.
Mr. Clark?
Yes.
Okay, I believe Lambert and Bartnick are still in, names are in nomination, so roll call vote, please.
Mr. Courtney?
Yes, Mr. Lambert?
Mr. Neal?
Mr. Bartnick?
We're going to have to postpone.
Mr. Lambert?
Lambert?
Mr. Stratt? Mr. Bartnick?
Bartnick.
Mr. Clark?
Dave Lambert.
I believe it's a 3-3 tie again.
I would like to make a motion on the vice chairman to elect Mr. Bartnick.
So,
I think that's out of order.
Mr. Chairman, I think we could be here all night on the same motion, and we need to know who's chair before we need to know who's vice chair. So this is highly unusual, but I'm going to suggest that you make a motion to postpone until we have a full board, because we might be here all night. And we'll move it up to the beginning of the agenda.
Mr. Neal?
I'm not sure if this would help things, Mr. Chairman. The question I would ask is it improper to give the two apparent candidates a minute or two to just speak and convey whatever they would want to convey? Maybe it would allow us to get a resolution. Maybe not, but is it improper to ask that?
Mr. Chairman,
Courtney.
I think that's a great idea, especially since our rules of procedure indicate that we should appoint tonight and at least give us one more chance at doing that.
Point of order, Mr. Chairman. I believe Mr. Neal's comment is, I think, appropriate if there's an active nomination on the floor, that a member could inquire if speeches or comments could be included. We don't have an active motion on the floor, so I would consider that to be inappropriate, but not Mr. Neal or anybody else could make a motion for nominations right now. Perhaps, Mr. Neal, if we could achieve the same thing if maybe we had a 5-minute adjournment, if that, break, where the two candidates maybe could speak to each other and then come back, and then after that, or to the board members individually. And I'm not sure that's appropriate with the Open Meetings Act. But related to, I'm completely acceptable of Mr. Neal's comment. If there are other nominations to be had, I think it's appropriate. But I do think a break might allow the two prospective candidates, even though they're not candidates right now, to speak to each other. So,
My suggestion would be that, because we have some more business to cover tonight, is that we, if you want to do another vote, what we can do is take nominations again, and then Mr. Bartnick and I can make a brief speech, if that's in order, and the wish of the board. And so if that's what you'd like to do, if somebody wants to.
I'd nominate Mr. Lambert.
Okay. And I would assume you want to nominate Mr. Bartnick? Okay.
Sure, I will
Okay.
nominate Mr. Bartnick, yes.
All right, so Lambert and Bartnick have been nominated. Is there a motion to close the nominations to allow speeches to be delivered? Mr. Clark moves to close nominations. Is there a second to close nominations?
I second it.
Mr. Neal seconds that motion. Any discussion on the motion to close nominations? Seeing none, we're ready for a roll call on the motion to close nominations.
Mr. Neal?
Yes.
Mr. Lambert?
Yes?
Mr. Stratt?
Yes.
Mr. Bartnick?
Yes.
Mr. Clark?
yes.
Mr. Courtney?
Yes.
Okay, the motion passes to close nominations. And now, if it's in order, I will, if Mr. Bartnick would like to go first to deliver a spiel, then I'll go. I'll give you the benefit of the doubt.
All right, well, thank you, Mr. Lambert. I think Mr. Lambert's done a fine job as chairman. I would remind all of us that This is a public body, and we benefit by having new blood, both on the individual seats as well as the officers. And I think at the same time, we benefit from having some experience on the board as well as on the officers. But I think the chairmanship is one of those seats that can benefit the most by a renewal on an annual basis. And in addition to that, I would suggest that although we have very good city attorneys that sit and advise us, I think my legal background may also be helpful during the course of implementing this new ordinance. Those are a couple things that I would point to.
I've enjoyed the opportunity to serve as chairman of the board for the past year, and had debated whether or not to seek re-election or not, because normally the board's policy for the past few years has been to rotate the position of chairman around. One of the things I looked at in deciding on this was, number one, getting the advice from Mr. Courtney as being the longest serving member of the board to get his input on whether it would be appropriate to seek re-election or not. And his input to me was to consider it that there was no reason to not consider running for re-election. I believe one of the key strengths that both Mr. Bartnick and I bring to this table is that as chairman, I've had the experience of chairing for the past year and also chairing city council meetings, and he brings a great skill as an attorney and as somebody who really delves in depth into a lot of these zoning issues that I think he provides a certain input on these decisions that I think he would do a better job as a vice chairman rather than a chairman. So I think we work as a great team, and I would like to see that team continue on for the next year. With that, I guess, unless anyone has any questions, we'll do another roll call. Ms. Bittner?
Mr. Lambert?
Lambert?
Mr. Stratt?
Bartley? I didn't hear that.
Bartnick, I think you said.
Mr. Bartnick?
Bartnick?
Mr. Clark?
Lambert.
Mr. Courtney?
Mr. Lambert?
Mr. Neal?
Mr. Lambert.
I believe the vote is 4-2, and appreciate the re-election. The appropriate thing now would be to take nominations for the office of vice chairman. Mr. Clark.
I'd like to nominate Mr. Bartnick for vice chairman.
Any other nominations for the office of vice chairman? Mr. Bartnick.
I would like to nominate Mr. Neal. I would not really be interested in serving as vice chair for some of the reasons I just spoke to earlier, and I think that the board needs to be refreshed on a rotating basis, including on those seats, on the offices. So I would not be interested in accepting that nomination. And I would nominate Mr. Neal.
So Mr. Neal's been nominated, and Mr. Bartnick has withdrawn his name as vice chairman then. Any further nominations for vice chairman? Seeing none, is there a motion to close the nominations for vice chairman? I guess the appropriate thing is, if there's only one person being nominated, would the appropriate motion be to close nominations and elect Mr. Neal vice chairman?
You would run it just like there were more than one, so
Okay,
go
all right.
ahead and vote to close and then just take your roll call.
I'll move to...
Point of order is,
Yes, Mr. Clark.
thank you, Mr. Chairman, of our legal counsel, under the rules, there isn't a second required for the nomination. I did nominate Mr. Bartnick. Mr. Bartnick isn't clearly determined that he's not interested. Do I, as the maker of that nomination motion, do I need to withdraw that, or can it be withdrawn, is the question?
You should withdraw the motion, good point, because
Okay.
it's on the floor.
Thank you,
Didn't it
Mr.
fail
Lancaster.
because of the lack of a second?
No, because
Everybody
we're
seconds the
nominated, so
nomination.
there's no second.
Mr. Chairman, thank you for hearing my point of order, and thank you for the legal counsel. I will withdraw Mr. Bartnick as my motion or nomination for vice chairman.
All right, is there a motion then to close nominations for the office of vice chairman?
I make that motion.
Okay, is there a second for the motion? I'll second the motion to close nominations for the office of vice chairman. Any discussion? Seeing none, the roll call to close the nominations for vice chairman.
Mr. Stratt?
Yes.
Mr. Bartnick?
Yes.
Mr. Clark?
Yes.
Mr. Courtney?
Yes.
Mr. Neal?
No.
Mr. Lambert?
Yes. The motion is passed to close the nominations for vice chairman. The roll call for the office of vice chairman, we have one nominee, Mr. Neal. So I guess you could either vote for Mr. Neal, or he'll probably vote for none of the above, I would assume. So the roll call, please.
Mr. Bartnick?
Mr. Neal?
Mr. Clark?
Neal.
Mr. Courtney?
Gee, I'm having a hard time. Mr. Neal?
Mr. Neal?
I'd do my best, Mr. Neal.
Mr. Lambert?
Mr. Neal.
Mr. Stratt?
Mr. Neal.
It's unanimous. Mr. Neal is elected vice chairman. Congratulations. And with that, is there any other business other than wrapping up the presentation from the study session?
No other business.
Okay, then why don't you carry on there where you left off earlier? Yes? Excuse myself. Okay.
Okay. Continuing on page 2 of the spreadsheet, the board had the ability to grant screen wall waivers or modifications. Those weren't variances, and people were held to a lesser standard than a variance. They were permitted and renewed by the Board of Zoning Appeals for a maximum of 2 years. That permission no longer exists. If someone did need a modification, you'd need a permanent variance, or at least approach it like a permanent variance. Now, the ordinance has changed the provisions that required separation of uses with the wall now provide actually predominantly landscaping. In certain instances, a wall is an option, but in most cases, landscaping can be provided. So applicants are going to have a choice as to what kind of separation is required between uses, and if they need any sort of relief from those provisions, they would come to the board as a variance, and that would be as a dimensional variance. It'd be up to the zoning administrator, me, and or the planning commission, to determine the status of screening for waivers that have expired under the old ordinance. For example, if a case expired after their 2-year period and they say they're to come to you, say, in October of this year, well, if they had vegetation, for example, that meets the city code, or the applicant was in a position to install vegetation that would meet the city code, there would be no need for them to come back. But anyone who has to come back, say they can't meet the city ordinance, would have to come under a variance. So that's how that would work under our new code.
Mr. Chairman?
Yes.
Can I direct a question? So how would that be set up as a policy that's going to be published or
Well, the
put
ordinance
out to
does,
the public?
the ordinance does a pretty good job of specifying exactly what kinds of vegetation, size of trees, spacing, that kind of thing need to go between what types of uses. So really, I think the determination by staff would basically be pretty simple. We'd look at it through the eyes of the code. If indeed the screening they have there is acceptable, then there'd be no need for them to come back. Or if they can install screening that meets the existing code, then there's no need for them to come in here too.
Thank you.
You're welcome. Let's see, a couple other items that I pulled from the ordinance, but I haven't had experience dealing with the board. Radio antenna height limits. Do we have experience in dealing with antenna height limits? That's specifically called out in the board. Do we? Okay.
We have, yes.
All right, it looks like under the old code,
Yeah.
we were allowed to do a modification as opposed to a variance. Now we'd have to do a variance. We'd apply the dimensional standards. Certain types of temporary buildings, this board was allowed to allowed for up to 2 years. Now, there's many more administrative allowances for types of buildings, including temporary construction buildings, structures and uses, sales offices, dwellings. For example, if a house burns in a single-family residential district and they want to rebuild it, but they want to bring in a temporary trailer for the construction period for the family to live in, that can be done administratively. And there's things that protect the neighborhood. For example, once you get a certificate of occupancy, you have a certain period of time where that trailer's got to be off the property to continue to maintain the single-family use of the site. So there's some specific standards in the ordinance in regards to locations, sizes, timeframes for a lot of these administrative allowances for temporary buildings and structures. So, I think what's good about that is people can come in and know right away, hey, if I want to get a pod to have on my property for whatever purpose, I know I can have it for X number of days. Now, if someone needs a modification to that, they can come in and also ask for a variance to that, although we'll do our best as staff to work with them.
Mr. Chairman, if I may, what are the requirements or the limitations under the new ordinance with regard to the radio antenna heights or the cellular tower heights, satellite tower heights? Is it a type of use or structure which is found in that chart? Or is it found
honestly,
somewhere else?
As part of my preparation for this, I examined specifically variance requirements, but, and the specific call-outs. For example, our previous Board of Appeals chapter specifically called out the ability to modify radio antenna height limits. So what I didn't do to prepare for this was examine in the current code if there are specific provisions outside of the zoning Board of Appeals section that might regulate specifically what you're talking about. And I can find that out. I just didn't come prepared for that tonight.
Okay, thank you.
Kind of a follow-up question to that as well, and that is, about 3 or 4 years ago, I remember City Council and Planning Commission were struggling and arguing over the amateur radio antenna ordinance. Does that ordinance get affected by this or not?
Well, if that particular provision in the ordinance still exists today, if anyone wanted to modify that, they would have to come in for a dimensional variance as opposed to the previously allowed modification, which essentially is a easier set of standards to apply for an applicant, a lower test. And I can get those answers for you and perhaps provide just a little write-up or directive in the next agenda, so everybody can look at that.
Mr. Chairman?
Yes.
Mr. Evans, if I could just inquire, I see under this section, it mentions sales offices, which we have clearly just disposed of that request just last meeting at the Suburban Collection, I can't remember which unit of their...
Yeah, I know which one you're talking about, yeah.
But I think there seems to be a lot of conversation about, these temporary sales, farmers market type of venues, and I think City Council dealt with that recently. Is a sales office a retail office? I mean, clearly, if you can buy a car, it has to be, but how does that fall? And then, for instance, what I'm concerned about is, I think those things tend to be good, and it shows as a sign of a vibrant community, but the point is, maybe the neighbors don't agree. And so if it's all handled administratively, and the public doesn't have a voice to this board or via this board, I guess that's where I'm just curious as to where we fall with that.
And I believe, let me take a quick look here, because I think I put my hands on it rather quickly, Glenn. I believe there's a call out in the new zoning ordinance. Council did pass a temporary merchant business ordinance, I think a year or two ago, which would allow, for example, I know we have one in the city of the Oakland Mall, Farm Boy, sells produce out of trailers. I believe there is a call out in the zoning ordinance that if you're regulated by that code, staff does not have the ability to grant an administrative approval for something like that. And if I can put my hands on it in the next minute, I will. Page 175. Oh, that's not where I was looking anyways. Yes.
Temporary seasonal.
Yes, temporary building structure and uses, where I summarize a lot of the things in the spreadsheet that's before us tonight. There is a specific exception that the section does not apply to any uses regulated by Chapter 61, temporary merchant businesses. So that's clearly in there. So if they're regulated, such as a use like Farm Boy, they would have to follow the temporary merchant business.
I'm sorry, what was that? Where is that? Temporary?
Yeah, Chapter 61 of the city code covers temporary merchant businesses. And the provisions in the zoning ordinance that allow administrative approval of certain temporary building structure uses do not apply to uses regulated by Chapter 61. And a Farm Boy is an example of that. He's got basically a 90-day permit to do those activities there. In summary, anyone receiving a temporary merchant business license, the particular use they're proposing needs to be an allowed use in the particular zoning district upon which the property they're proposing it. So for example, in the instance of the Farm Boy use, retail sales is allowed. The Farm Boy sells retail. He's allowed up to 90 days to have the operation there. One caveat that Chapter 61 provides is that the operation must be broken down in its entirety on a nightly basis. So the difference there is, A, you've got 90 days. I don't believe there's anything close to 90 days that we could administratively approve in this ordinance under temporary structures, buildings, and uses. But furthermore, you don't have to take down your temporary construction building. You don't have to take down your portable on-demand storage that you may have because you're painting the house and you need to move the furniture, or maybe you've had a flood or something. So there's some balance there as to, and limits, I might say, and predictability as to what the zoning administrator can do as guided by the ordinance. Did that answer your question?
Yes, thank you very much.
All right. Moving on here, let's see. Planning Commission action on site plans. For plans required to be reviewed by the Planning Commission, if they need a variance, you submit first to the Planning Commission, but the Planning Commission can't take action until there's disposition on those variances by the Board of Appeals. So the net effect is the Planning Commission cannot make a decision on something until the variances are either granted or not granted. So they'll know definitively when they're required to vote on something like that, just what they're getting when the people return back from the Board of Appeals. And that's really no change from what we had before, but I wanted to make it clear that that's still in there. And that's the order that those plans will be processed with. And finally, it basically clarified, summarized, and codified certain appeals of administrative decisions and interpretations. Gives more specific. The new ordinance gives more specific directions how this zoning board should address any appeals of administrative decisions, and would further clarifies the scope of the board relative to interpreting the zoning ordinance. So the old ordinance contained provisions like that in various sections, but I think this ordinance kind of brought those together and really spelled those out a little more clearly. But essentially the same powers of the board do exist, just written in a more clarified format. And those are the summary of the changes that apply to the Board of Appeals. And if there's any questions now or in the future, please don't hesitate to shoot me an email, give me a call, stop in. I certainly want to encourage that we don't have to wait for a meeting unless you think it's important for everyone to hear. Mike.
Mr. Chairman, actually, what is the difference between the, what we were just talking about, addressing specific appeals of administrative decisions? How is that interpretation of the ordinance, those types of appeals?
You know, honestly,
how is that different, or when would it arise as opposed to, you know, the run-of-the-mill?
Actually, based on language, I don't think it would necessarily arise. The power is really the same. We had a couple different, at least 3 sections that talked about that, and they were spread about the ordinance. In the same chapter 43, but just about. Now, they're basically all under section 1504C4 and 1504D. And essentially, other than the specific language that kind of gives them more specific direction on some of the factors they can consider. I think the power is the same. I haven't, I don't think it was evident, the change I don't think was significant enough to go over it, word by word, as opposed to, yeah, okay.
Sure, thank you.
Sure. And that's all I have to provide.
Any more questions on the new ordinance? I have one quick question. I think you pretty much touched on it, but from now on, when we hear the commercial vehicle appeals, we'll no longer be using that three-part test that we've used in the past. We're going to be using the strict variance
Right.
dimensional requirements.
Use the dimensional requirements that we would use for any other variance, yes.
Are there any applications in the pipeline right now that they are aware of the fact that they may need to apply with the new rules, or?
No, but I think what's going to happen is as our tickler dates come up for ones we've granted in the last couple of years, those individuals are going to come in, and I'm going to have to sit down with them and explain to them that there's a new standard they need to be aware, and when they make their presentation, they want to try to incorporate as many of those practical difficulty demonstrations in their case that they can.
I don't know if it's possible, just as a courtesy to them, that as you see them coming up, that you might want to give them a little bit more advance notice to make them aware of the fact that it's a different ballgame now completely than the way it used to be, so that they're prepared for a lot more documentation that they've had to provide in the past.
I think you raise a good point, and I'm pretty confident we can do that, because I don't think we deal with that many, maybe a handful. In addition to, for whatever reason, I'd have to say, for whatever reason, someone's completely surprised. As the code enforcement manager as well, we can work with people. We would understand as staff that this was not what they expected when they received their first variance, and sometimes it's not the easiest thing to simply drive your vehicle and not park where you've been allowed to park it for, maybe you've had successive permissions, and everything's gone smoothly, and you've invested into things on your property like bushes and screening and that. So in a worst case scenario, staff can work with people who perhaps might not have a comfort level with seeking a variance, giving some more time to find an alternate. And I think we would be justified, not only to the person who might be affected, but if neighbors were asking, well, how come they're not back there? Look, let's try to be fair with this. He didn't know 2 years ago that this ordinance would have been changed and there would be a new test applied. So I think we can do both. But yeah, I think it's a great idea that we give those guys, those applicants a heads up so they can at least start to prepare.
Any more questions from
Mr. Chairman?
Mr. Barton?
I would just play the devil's advocate on that and take the opposite position, which is that really it's not the position of the staff to go out there and promote one way or the other on those items. And then secondly, the people that sought those permissions knew when they sought those permissions that they were temporary and limited permissions.
Any more questions from the board for staff on the new ordinance? Did we pretty much cover the other item that was from the study session on revisions to the rules of procedure? Has that been covered, or?
Oh, you know what?
Courtney?
They need to be reviewed, and I don't think staff has had time to really review them.
Right, I know I indicated, and I threw that on there, and essentially, they do need to be reviewed and modified at minimum for some changes, some minor changes, but I guess I would just ask the board to take a look at our rules of procedure, and as a matter of process, perhaps if there's any adjustments that we might want to consider inclusion over and above maybe what the ordinance, not say over and above, but in addition to what the ordinance would mandate, maybe now is the time to discuss those, and maybe there's some things that we might want to proceed with differently that'll not only help the board, but assist the public in proceeding with our meetings, a full public understanding, transparency, whatever it might be. I do have a copy of the rules of procedure in hard copy here for anyone. I can have a copy emailed to everyone if they just want a current one. I see people nodding. You want me to do that? I'll email. Good enough? Okay. Ken, I'm not going to email you.
January 2005, right?
Yep, that's the one we have, January 2005. And then, if we have comments that we think we should include, do you think I think it would be appropriate if people wanted to forward me comments before the meeting, we could put them all in the packet. But we can also wait for the meeting for everyone to bring up their comments too. I'm open to whatever the board thinks is a good idea.
One question, what's the legal requirement on having a meeting under the state act? Do you know how many days notice or hours or?
You mean in order to notify someone
No, just for the public.
for the public? I believe it is at least let's ask our clerk if she remembers that. What's the notice provision for meetings? How many,
Excuse me, I believe
2 days?
if it's a special meeting, it's 48 hours, or if it's a regular meeting, it's 48 hours.
How many?
48 hours.
Special?
If it's a special meeting, I think it's less than that, but for a regular meeting, it's 48 hours.
It is, well, we require 24 in here, and I don't know if that's sufficient. That's why I was,
Right. Mr. Chair, and to support what Paul is saying, you can adapt your rules of procedure. Some people even put in their rules of procedure how to do an election.
Yep.
But, if that is something you want to clarify for next time, or they put time limits on them. And if you wish, maybe we can send you some of the minutes from the other commissions that serve, so you can see what they're doing, if you would be interested in that, like the Planning Commission bylaws, so that you know if you want to adopt anything that you think might be, and if it's appropriate. And it's up to you, but basically, they're your rules, and you can adopt what you think is appropriate.
I was wondering, one thing that we might want to include in the procedures is the procedure for having the alternate member elevated in case somebody is not here or they step down, whether or not we want to, when the people are appointed, say this is alternate A and alternate B, and then we will switch off, as Mr. Evans had suggested he had done in other communities, so.
That's a great idea. Just anything that puts in writing how you want things to flow.
If I could make a suggestion, maybe I'm putting Sue on the spot, but perhaps, Sue, maybe you and I can at least come up with a red line version of what we have now, just to,
Sure.
for next month, just to...
We can make a proposal, and you folks can edit it and X out anything you don't like, or add in things that you want. That would be helpful. Okay?
Is that fair with everyone? Any comment either way? Does that sound good? Did you?
Sounds wonderful. We're agreeable on this side of the room.
All right.
Any further questions from the board on?
unless there's an objection, I would think they should put something in about the election and follow Mr. Bartnick's opinion as to how it, separate.
Although personally, that was very exciting for me, because I haven't had that many parliamentary questions in about 20 years, so.
But that would, apparently, that's what the majority would
Like the
like.
2000 presidential race, the Electoral College and the popular vote and so
Yes.
forth.
Voting machine.
It'll go in the history books, or at least the Troy Times, so.
Did you have some, Mr. Neal?
Yes, as
Just
Paul
one-
said, hanging chads.
Just one question, a procedural question about meetings in general. I think this was spoke to in an earlier training session. But what constitutes a meeting? Meaning, if we have an item that's come before the board, for example, it's the best example that I can think of, but it's been postponed, such as item A was tonight. If two members speak about the issue in whatever type of communication, electronic, verbal, telephone, I don't care what, does that constitute a meeting? And if so, well, let me ask you this, where is the threshold where we cross the line that it is a meeting and we're not complying with the Open Meetings Act? I guess some guidance on that would be useful.
Well, basically, the Open Meetings Act says that any time a quorum is meeting to deliberate towards a decision, it's an open meeting. However, as lawyers, we always think worst-case scenario, and we tell you that, first of all, any emails that you write are discoverable, so that if we were ever sued and if somebody asked us to produce them, we would have to give them, even if they're on your personal computers. Any notes that you may take. So what we do is we use a test that says that you are to avoid any appearances of impropriety. Basically, if you are discussing just facts and not talking about how you're going to vote, someone could challenge that, but our argument would be you're not deliberating towards a decision. Basically, if there's just two of you, there's less worry than if there's a quorum. Anytime that there are four of you together, you better not talk about any BZA business or ZBA business, as that case may be. If there's two of you and you happen to run into each other, if you're viewing a site, I don't know that there would ever be an issue if you just strictly talked about, dimensions and things of that nature. But if you started deliberating about how you're going to vote, then that's a violation of the Open Meetings Act. You should be very careful about that.
Thank you.
Any more on the rules or the new zoning rules? Any more miscellaneous business? Mr. Clark?
Thank you, Mr. Chairman. I have a point of personal privilege here tonight to congratulate our chairman on his commencement and graduation from the University of Detroit. He earned a Master's of Arts, a Master's in Arts of Economics, if I'm not incorrect. And I only knew, well, I had spoken to him about it past, but I knew he graduated because I saw it on Facebook. So I know that it's, you've been working on that for quite some time, so congratulations to you.
Thank you very much.
Economics?
Yes.
Wise choice.
Any further business to come in front of the board? Just one brief comment, and then we'll adjourn. Ms. Bittner is not only a recording secretary, she works in the clerk's office, and she told me before the meeting tonight that she's going to become the new city clerk in Berkeley. So
Right.
Congratulations.
Thank
And we decided to give you a fun meeting to take the minutes for tonight.
Kept me on my toes.
Seeing no further business, the meeting is adjourned.